Hello. So today we are going to discuss an important news that is regarding with removal of the judges, specifically in the context of Allahabad High Court judge, that is Justice Shekhar Kumar Yadav. So the background is this: Justice Shekhar Kumar Yadav, in one of the program that is organized by Vishwa Hindu Parishad, he made a remark that is not considered a secular remark. These remarks he had made against the minority community, specifically Muslim community. So, because of that, opposition member of parliament, especially Lok Sabha and Rajya Sabha, they are initiating a motion, okay, against Justice Shekhar Kumar Yadav to remove him. Clear this? So, just I want to make it clear here is that till now, since independent, that means since the time that we got the constitution, no judge has been removed, and neither Supreme Court judge nor the High Court judge till now. That is a reality. Our entire this independent Indian history, no judge has been removed till now. So the issue was this: judges' anti-Muslim remarks, opposition MPs start signing on the notice for the impeachment. One thing just I want to make it clear: the term impeachment has not been mentioned for the judges of the Supreme Court or High Court. The term impeachment has been reserved only for the President of India. Correct? If you read article number 61, you will notice under article number 61 of Indian Constitution, the term impeachment is mentioned. Then for the judges, the term that is mentioned, it is removal of judges. Removal of judges. That means term impeachment is not mentioned for in case of judges. That means this headline is technically incorrect. Clear? This headline technically incorrect. And this removal of judge, it is mentioned under article number 124.4 for the Supreme Court judge and under article number 218 for the High Court judge. Again, be clear here. For the Supreme Court judge removal process has been mentioned under article number 124 part 4, and for High Court judge under article number 218. Again, just I want to make it clear here, the removal process for both Supreme Court judge as well as for the High Court judge, both are same, exactly same, copy paste. We will cover that things later. Now, these are the number of judges against whom this removal process was started, but it was not been completed because of some reasons. We will discuss that part at the later stage of this video. Now we are moving again. So when we read article number 124, where it is mentioned about the removal of Supreme Court judge, and same content will be available under article number 218 for the High Court judge also. Here you will notice what is mentioned, कि Supreme Court judge will going to be removed by an order of the President passed after by each house of the Parliament, supported by majority of the total membership of the House and by majority of not less than 2/3 of the members of the House present in voting, and such removal on the ground of proved misbehavior or incapacity. Only three information you are getting from this article number 124 ka part 4. First is the judges will going to be removed by the President of India. Second information, what are the majorities required in the Parliament, that is a special majority. And third information you will get, what are the grounds are available for the removal of judges Supreme Court. So that is what is impeachment. So impeachment is mentioned under article number basically 124.4 and article 218 already we have covered, and the grounds which are mentioned, they are proved misbehavior and incapacity. So now just I want to make it clear what is the meaning of this term proved misbehavior. So proved misbehavior simply means, okay, if you take it, it simply means होता है corruption. Okay, it means like corruption, or for example sexual misconduct or misuse of public money. Clear? Or you can say that it is misuse of public money also. That is the example of proved misbehavior. Or incapacity means क्या होता है? Incapacity simply means होता है mental incapacity or physical incapacity. Correct? That comes. So this explanation has not been mentioned here under article number 124. Now we will move further. So who initiated this process? That means removal process for the judges of the Supreme Court and High Court, it was started by whom? So if this process start in the Lok Sabha, then at least 100 Lok Sabha member of parliament support is required. If it is started in the Rajya Sabha, then at least 50 Rajya Sabha member of parliament support is required. Clear this? So we can see here is, In case of Rajya Sabha, in this particular case of Justice Shekhar Kumar Yadav, this process was initiated by Kapil Sibbal. He is the independent Rajya Sabha member. And in the Lok Sabha, it was started by Aga Sayyed Rahullah Mehdi, that is Lok Sabha member of parliament. Clear this? So this process, so now it one thing is clear कि अगर ये process आप लोक सभा में start कर रहे हो, then at least 100 लोक सभा members signature is required. If you start in the राज्य सभा, then at least 50 members support is required. जैसे आप डिस्ट्रिक्ट मजिस्ट्रेट के पास जाते हो कोई काम करवाने के लिए गांव से, तो गांव के सारे लोगों का क्या होता है, आप सिग्नेचर लेके जाते हो ताकि आपको एक सपोर्ट मिले. सेम यहाँ पे भी है कि अगर राज्यसभा में इफ यू आर स्टार्टिंग प्रोसेस एटलीस्ट 50 राज्यसभा मेंबर दे शुड सपोर्ट इट. अगर लोकसभा में तो 100 लोकसभा मेंबर दे शुड सपोर्ट योर दिस रिमूवल मोशन. नेक्स्ट इज वेयर दिस मेंशन इंटायर प्रोसीजर. ये इंटायर प्रोसीजर मेंशन कहां पे है? सी अभी हमने आर्टिकल नंबर 124 देखा था, उसमें पूरा प्रोसीजर मेंशन नहीं है. उसमें सिर्फ इतना मेंशन है कि व्हाट इज द मेजॉरिटी इज रिक्वायर्ड एंड हु विल गोइंग टू रिमूव इट एंड व्हाट आर द ग्राउंड, दैट्स इट. इसके अलावा कोई इंटायर प्रोसीजर मेंशन नहीं. दैट मींस इन दैट आर्टिकल नंबर 124 ये मेंशन नहीं है फॉर एग्जांपल कि कोई इन्वेस्टिगेशन होगा, इफ इन्वेस्टिगेशन इज गोइंग टू हैपन देन who will be the members of that investigation committees. All these things are not mentioned in the constitution. Be clear here. So it basically is laid down in the Judges Inquiry Act 1968. ये कहाँ पे mention है पूरा process? ये पूरा process mention है Judges Inquiry Act 1968. इसी पे one question was asked in UPSC. Previous year's question है UPSC prelims में. This question was asked in the UPSC prelims. I think in 2018 this was question. So that is the reason these are important point that you have to notice. And next part if we move, नेक्स्ट पार्ट में क्या है, हाउ डज द इम्पीचमेंट प्रोसेस वर्क्स बेसिकली. तो ऑलरेडी हमने बताया कि लोकसभा में 100 लोकसभा मेंबर दे शुड सपोर्ट इट. इफ दिस प्रोसेस स्टार्ट इन द राज्यसभा देन 50 मेंबर्स. उसके बाद क्या होगा, दिस पिटीशन विद दिस सपोर्ट it is going to be submitted to the speaker in case of Lok Sabha or the chairman in case of Rajya Sabha. This is clear now. Now it is up to the speaker whether to accept this petition or not. This is a prerogative of the speaker, because if prima facie evidence is not available then the speaker can reject it also. Same for example chairperson of Rajya Sabha. If this process start in the Rajya Sabha, then it is the prerogative of the Rajya Sabha chairman whether to accept or not. It is based on the prima facie evidence. Clear this? Now committee formation. Once this petition has been accepted by either in case of Lok Sabha it was by Lok Sabha speaker, in case of Rajya Sabha by Rajya Sabha chairman, then a 3-member committee will going to form. Kitna member? 3-member committee. Now who will be those 3 members? These will be Chief Justice of India or the Supreme Court judge. कोई भी हो सकता है, Chief Justice of India और Supreme Court judge. ऐसा क्यों? See, if this removal process is against Judge of the High Court, Chief Justice of the High Court or Judge of the Supreme Court, then Chief Justice of India can be the chairman of that. Agar for example if this removal process is against Chief Justice of India himself or herself, then Supreme Court judge also can be the part of it. Second member will be Chief Justice of any High Court. कोई भी हाई कोर्ट होगा उसका एक चीफ जस्टिस ऑफ इंडिया भी होगा. थर्ड मेंबर होगा ए डिस्टिंग्विश्ड ज्यूरिस्ट. यहाँ पे इंपॉर्टेंट इंफॉर्मेशन है, who will decide that who can be that distinguished jurist? That will be decided by a speaker or the chairman. That means if process start in the Lok Sabha, then the speaker will decide. If this process start in the Rajya Sabha, then chairman is going to decide. This is very important information because in the UPSC prelims exam they can write here as a president of India also. So ध्यान रखना, it is not the president of India, it is basically a speaker and the chairman who will decide basically who will be the distinguished jurist. So these are the 3 members committee that is required. उसके बाद क्या होगा after that? Investigation and reporting. तो basically क्या है कि after concluding its investigation, the committee क्या है, committee is going to submit its report. अगर लोकसभा में बना था then it will going to submit to the Lok Sabha, otherwise it is going to submit to the Rajya Sabha. If the committee finds the judge guilty, ध्यान रखना, if the committee finds, ये क्या करें committee, they will going to ask the questions to the particular judge, that is concerned judge, or they are going to ask questions to the various witness, cross examinations. All these things will going to be done, and after that if committee finds the judge guilty, then the report is then placed before the respective house of the parliament for consideration. That means if this committee was formed by the Lok Sabha, then report will be submitted to the Lok Sabha. If this committee was formed by the Rajya Sabha, then this will going to submit it to the Rajya Sabha only. Correct? अगर फॉर एग्जाम्पल इफ दिस कमेटी डज नॉट फाइंड एनी सफिशिएंट एविडेंस, ध्यान रखना दिस इज वेरी इंपॉर्टेंट, इफ दिस कमेटी डज नॉट फाइंड एनी सफिशिएंट एविडेंस तो क्या होगा, मैटर इज ड्रॉप्ड हियर इटसेल्फ, प्रोसेस स्टॉप्ड, उसके बाद कोई डिबेट नहीं, पार्लियामेंट में कोई वोटिंग नहीं, प्रोसेस स्टॉप्ड हियर इटसेल्फ, क्लियर दिस। नाउ ना उसके बाद वोटिंग होगा, ये वोटिंग कब होगा, व्हेन कमेटी हैज फाउंड दैट जज इज गिल्टी, देन उसके बाद क्या होगा, द मोशन टू पास इट मस्ट रिसीव ए मेजॉरिटी ऑफ बोथ, दैट इज टोटल मेंबरशिप ऑफ द हाउस, दैट मींस कि लाइक एग्जांपल इफ इट इज कमिंग इन द लोकसभा, इफ इट इज कमिंग इन द लोकसभा, देन लोकसभा में टोटल मेंबर्स अगर आप देखें लाइक 543 मेंबर्स आर देयर, तो डिवाइड बाय 2 + 1, at least this total membership of that house, that majority is required, plus 2/3 of the present and voting, 2/3 of present and voting, that is also required, that means it is same, okay, that is majority that is required under article number 368, that means जो आप cover करते हो ना amendment of the constitution, amendment of the constitution, same actually support is required, that is a special majority is required for the removal of judge of the सुप्रीम कोर्ट एज वेल एज जज ऑफ द हाई कोर्ट, क्लियर दिस। उसके बाद ये दोनों हाउस में जाएगा, फर्स्ट अगर फॉर एग्जांपल प्रोसेस स्टार्ट लोकसभा में, तो फर्स्ट दिस विल गोइंग टू पास इन द लोकसभा विद स्पेशल मेजॉरिटी अकॉर्डिंग टू आर्टिकल नंबर 368, उसके बाद इट विल गो टू द राज्यसभा एंड देन राज्यसभा अगेन नीड टू पास विद सम सेम स्पेशल मेजॉरिटी, दैट इज अंडर आर्टिकल नंबर 368, दैट इज मेजॉरिटी ऑफ द टोटल हाउस प्लस 2/3 ऑफ प्रेजेंट एंड वोटिंग, आफ्टर दैट इट विल बी प्रेजेंटेड टू द प्रेसिडेंट ऑफ इंडिया, करेक्ट है, उसके बाद प्रेसिडेंट अप्रूवल इज रिक्वायर्ड, सो इफ पास्ड बाय द पार्लियामेंट दैट इज बोथ द हाउसेस, देन प्रेसिडेंट नीड टू साइन इट, देन प्रेसिडेंट ऑफ इंडिया इशू द रिमूवल ऑर्डर। लेकिन एक चीज ध्यान रखना, दिस इंटायर प्रोसेस शुड बी कंप्लीटेड विद इन 1 सेशन ओनली, अगेन ये बहुत इंपॉर्टेंट है फॉर यू टू नोट डाउन for the prelims exam, entire process need to be completed within 1 session, that is what it is mentioned under article number 124 part 4. After that I will go कि these are the instances when judges were removed, तो सबसे first case था, it was Justice V Ramaswamy in basically 1993, तो it was, what was the ground was proved misbehavior, basically the misuse of the public fund, उसका केस था इसमें, करेक्ट है, और इसमें मोशन फेल हो गया था लोकसभा में, बिकॉज उसमें जो कांग्रेस गवर्नमेंट थी, सॉरी कांग्रेस जो पार्टी थी, कांग्रेस पार्टी हैज नॉट सपोर्टेड, एंड बिकॉज ऑफ दिस पंजाब एंड बेसिकली हरियाणा चीफ जस्टिस ऑफ दिस जस्टिस वी रामास्वामी ही वाज नॉट रिमूव्ड, तो ये भी प्रोसेस फेल हो गया था बिकॉज इट दिस मोशन वाज फेल्ड इन द लोकसभा। उसके बाद आया फॉर एग्जांपल जस्टिस सुमित्रा सेन का नाम आया, तो जस्टिस सुमित्रा सेन इन 2011 के बाद का काम है, 2011 केस था वही करप्शन का, दैट इज मिसयूज ऑफ पब्लिक फंड्स, इनके केस में डेफिनेटली ही वाज इम्पीच्ड इन द राज्यसभा, ही वाज इम्पीच्ड बाय द राज्यसभा डेफिनेटली, उसके बाद मोशन केम टू द लोकसभा, लेकिन बिफोर एक्चुअली लोकसभा इज गोइंग टू वोट, दिस गाय हैज एक्चुअली गिव द रेजिग्नेशन, उसने रिजाइन दे दिया, एंड प्रेसिडेंट ऑफ इंडिया हैज एक्सेप्टेड द रेजिग्नेशन, तो इनका भी प्रोसेस कंप्लीट नहीं हो पाया। एंड सेम केस हुआ था जस्टिस पीडी दिनाकरन के केस में, सिक्किम हाई कोर्ट जज थे, अगेन द सेम ईयर 2011 ओनली। उसके बाद जस्टिस एस के गांगली की बात करें तो इन 2015 इट वाज रिगार्डिंग सेक्सुअल हरासमेंट केस था, बट इट वाज क्लियर्ड बाय इन्वेस्टिगेशन कमेटी, बिकॉज जो 3 मेंबर इन्वेस्टिगेशन कमेटी वाज फॉर्म, उन्होंने उनको गिल्टी ही नहीं माना, करेक्ट है, जबकि यहाँ पे गिल्टी माना गया था। जस्टिस वी रामास्वामी के केस में 14 चार्जेस लगे थे, आउट ऑफ दैट 14 चार्जेस 11 चार्जेस में ही वाज गिल्टी, बट स्टिल ही वाज नॉट रिमूव्ड। तो आप देख रहे हो, बिकॉज इट इज अ पॉलिटिकल प्रेशर, पॉलिटिकल प्रोसेस आल्सो, अंडरस्टूड आपने। सो हियर फॉर एग्जांपल यू कैन सी कि इन आउट ऑफ दिस 14 चार्जेस 11 चार्जेस में ही वाज फाउंड गिल्टी, बट स्टिल ही वाज नॉट रिमूव्ड बिकॉज वी वर नॉट हैविंग एंटायर पॉलिटिकल सपोर्ट। सो इट इज अ पॉलिटिकल प्रोसेस आल्सो, विदाउट द सपोर्ट ऑफ पॉलिटिकल पार्टीज दोज हु आर रूलिंग, you cannot remove the judge of supreme court and high court. Then for example आप आ जाओ जस्टिस जेपी पर्दीवाला का केस ले लो, remarks on, because he made a remark on the castiest remarks he made basically regarding reservation policy, so motion but remark this actually the process was stopped, reason is this, he actually removed those actually terms that he used in the judgment। उसके बाद जस्टिस सीवी नागार्जुन का बात करो 2017 में, इट वाज बेसिकली विक्टिमाइजेशन ऑफ दलित जज, बट मोशन फेल्ड ड्यू टू एमपीज विथड्रॉइंग सिग्नेचर्स, टोटल सपोर्ट नहीं हमको मिला। उसके बाद आप लास्ट था चीफ जस्टिस दीपक मिश्रा का केस 2018 में, अलेज्ड मिसयूज ऑफ ऑफिस का था इसमें, अगेन मोशन रिजेक्टेड एट द प्रिलिमिनरी स्टेज ऑन राज्यसभा बिकॉज चेयरमैन जो उसमें थे वेंकैया नायडू, ही हैज नॉट एक्सेप्टेड this. Okay, for example, the motion and petition that is filed there. So because of that, Chief Justice Deepak Misra, he was also not removed because motion was stopped or motion was not able to start it yet. So these are the cases that I have discussed. I hope you understood about this, how the judges, they are removed, okay, in according to our constitution and according to Judges Inquiry Act 1968. Thank you, and follow for more such updates.